Okay, well, I make it a couple of minutes past 2 o'clock. So I think if Maria agrees, I'll open and welcome everyone to this joint webinar between Saunders Law and No5 Chambers. Thank you so much for taking the time out of your day to join us in what I hope is going to be a really informative and hopefully interesting webinar. So my name is Matthew Purcell. I am a partner at Saunders Law, a litigation boutique in the centre of London, and I lead a team dealing with commercial litigation and dispute resolution, often with an international element with clients, particularly in America, Asia, and the Middle East. So that's me. Maria, do you want to tell everyone about yourself?
Thank you, Matthew. I'm a barrister at No5 Chambers. I specialise in commercial litigation, often with an international element, and I'm also registered as a practitioner at the DIFC Courts.
And I guess we should probably explain to our audience why we both chosen to work together on this webinar and how our paths have crossed.
Yes, absolutely. So Matthew and I have been working closely together on a large international fraud matter arising out of a joint venture agreement. We're both very active in complex cross-border litigation, and we've both been working on a number of these cases independently recently, and we thought it would be a good idea to collaborate and share with our litigation colleagues from around the world.
Yeah, absolutely. And with London being such a global financial and legal centre, we think we're the right people to handle such work and hope to share some of our knowledge. Just to set the scene, we're conducting 2 seminars to help our litigation friends across differing time zones. But the regime that we're going to be discussing in this jurisdiction applies to judgments obtained from almost every corner of the globe, including Asia, the US, Middle East, and DIFC. So if you've got friends or colleagues from different jurisdictions who can't join this afternoon, we'll also be doing a very similar webinar tomorrow at 9 a.m.
Yes, and the plan for this webinar today is we intend for it to last for about 45 minutes and then for 15 minutes questions and answers at the end. So a bit of housekeeping, there's a chat box. We encourage you to use the chat box. If you have any questions and answers, pop them in the Q&A box, and then Matthew and I can get to those easily at the end of the webinar. Throughout, we will also be taking some polls, and we would love it if you would answer these so we can tailor any follow-ups and discussions. And obviously, please let us know as well if you're experiencing any technical difficulties.
Yeah, I was just about to add that. Do let us know. Hopefully you can hear us clearly, but any problems, we can try and sort those. I think also us lawyers, I think no matter where we're based, we love a good disclaimer. So I should probably finalise the introductions by saying that Maria and I know what we're doing, but this is guidance and not intended to be formal legal advice. If you've got any questions and need some more formal legal advice, please contact us and we'd be happy to help. So I think it's over to Maria to kick us off, and Maria will be talking about the common law regime and the basis for enforcing the judgments that we're talking about.
Okay, so first of all, when might this situation arise? When may we need to consider, firstly, recognising a judgment obtained from overseas, and then secondly, enforcing that judgment? Well, it's mainly because either a defendant is based in the United Kingdom or a defendant has assets here which we want to go against to enforce. So today we're talking about the common law regime, and Matthew and I, we're focusing on the United States and the DIFC courts, but essentially there are so many jurisdictions that fall within the common law regime, and that includes China, Brazil, Russia, and essentially it's any jurisdiction which doesn't have a treaty in place by which either party's judgments may be enforced by the other party's courts. Essentially what needs to happen in the absence of that treaty is to apply the common law rules to firstly have the judgment recognised in the courts here, and secondly to have that judgment enforced.
And I think it's quite unusual given, for example, the special relationship that we have with America, which is obviously political, but one of enormous trade as well. I think it's quite unusual when you start looking into the treaties that, in fact, we have very few bilateral treaties, despite huge volumes of trade and the special relationship with the US and also with China. It just seems odd when you start operating in this sphere.
Yeah, absolutely. And I think First of all, it's important to take a step back and assess, right, which actual regime applies to the judgment that I have. Does it fall under the common law regime, or does it fall under the Lugano Convention or any of the other specific regimes that apply? And there's a lot of things that practitioners can do to establish which regime applies. There's a lot of resources out there. One of them being the HCCH. They have a very helpful table which sets out the status of all of the countries and which regimes apply to each of those countries. There is also some helpful information in the Standard International Forum of Commercial Courts memorandum that summarises the position for over 30 jurisdictions in the world. And also there's lots of specific guidance. For example, there's the Memorandum of Guidance as to enforcement between the DIFC courts and the Commercial Court in the Queen's Bench Division.
There's also the foreign process section at the RCJ, and certainly in this country, and I think talking to my friends in the US, court staff often get quite a bad rap for not being particularly helpful. However, the foreign process section at the RCJ really are exceptionally helpful. They recognise that procedurally, when you involve different jurisdictions, things get quite complicated, and practitioners don't necessarily deal with these areas of law every day. And they're actually, for court staff, if I can say this, normally very giving of their time and very, very knowledgeable. So if you get stuck on the court process, although you can't actually rely on what they say as a matter of law, they really are worth having a chat to if you get stuck and just need some pointers.
Yes, absolutely. I know a number of lawyers that call the foreign process section quite regularly for assistance.
Definitely.
Okay, so before the judgment can be enforced, I've already established that the judgment needs to be recognised. So a judgment will only be recognised under the common law rules where the person against whom the judgment was given was, at the time proceedings were started, present in the foreign jurisdiction, or that person against whom the judgment was given was the claimant or counterclaimed in the proceedings in the foreign court. If the person against whom the judgment was given had actually submitted to the jurisdiction of that court by voluntarily appearing in the proceedings, and if the person against whom the judgment was given had, before the commencement of the proceedings, submitted to the jurisdiction of that court. And these are all four elements which Matthew is going to go into in much more detail. A very helpful practitioner text is Dicey, Morris and Collins on the conflict of laws. That sets out the main principles, but also there's a case of Rubin in Eurofinance, which goes through the main principles also. And Matthew will go through some of those with us later on. So, what needs to be established again is that the judgment must be for a definite sum of money. So it has to be an exact definite sum. An action will not be supported if the judgment requires anything else to be undertaken as part of the order, i.e. a requirement to specifically do some kind of act. That's not something that you could try and enforce over here. The regime will not apply to the enforcement of a fine, penalty or tax of another jurisdiction. And again, the judgment must be absolutely final and conclusive. An appeal does not alter the finality of a judgment, and even a default judgment is taken to be final. In the United States, the judgment only needs to be final in the district where it was given. So how do we go about starting the process? So effectively, it's a fresh claim. Fresh proceedings must be issued by filing a claim and a statement of case, particulars of claim, with a certified copy of the judgment being exhibited with translated versions if applicable, and Matthew's going to touch on that later. Now, it's quite easy to obtain certified copies of judgments, particularly you can apply to the DIFC Courts for a copy of any certified judgment, and also record requests can be made to the applicable courts in the United States. It should be very straightforward. A claim should simply be commenced, and then ideally the matter can simply move to summary judgment.
So I'm going to now move on to talk about some of the practical things that need to be considered or assessed when we're considering enforcing a judgment from countries where the common law applies in this jurisdiction. For those of you that aren't based in this jurisdiction, you may know this, but we operate a dualist legal profession where, broadly speaking, solicitors and barristers work in tandem to prepare and progress disputes. Generally speaking, a solicitor will deal with the client, take instructions and provide some initial advice, and will then instruct a barrister to work alongside them to draft court documentation, present the case, and to provide further advice. As ever, there's some nuance to this, but in cases such as these, particularly when they're quite high value, typically we would as a practice, and I think as solicitors generally, get a barrister like Maria on board quite early on, because the process itself on paper looks quite straightforward, but there are definitely some traps for the unwary. Another important point that I'm going to emphasize again, and that Maria's touched on, is that it's really important to remember that you are issuing a completely fresh claim in this jurisdiction. But it's a claim founded, so the cause of action is the judgment of the foreign court. There are some shortcuts that we can take, and Maria's alluded to one being summary judgment, to avoid a full trial of issue. And I'll discuss that in a bit more detail later, but I will keep reminding everyone of this again. This involves issuing a completely fresh court claim. The court will treat this as a live dispute where both parties are entitled to argue their respective positions. As Maria also alluded to earlier, you would be starting this new claim if you knew or suspect that the judgment debtor had assets in this jurisdiction, and really it definitely is all about the money. If there are not assets in this jurisdiction that can be attached to any judgment you get from the claim that you issue, then there really is just not a huge amount of point in going through this process. And like in many jurisdictions, we would be looking for evidence of property ownership, legal or beneficial, other land, bank accounts, money owed by third parties to the judgment debtor, shares, stakes in the business, high value goods, cars, antiques, etc., that sort of thing. You need to be really sure where these assets are and that they are in the judgment debtor's name. You could start by asking, but as with most debtors, I wouldn't necessarily expect cooperation. But a good solicitor will be able to carry out due diligence, including checking company's house for a company's solvency, for example, and level of assets to debt. In this jurisdiction, you can't access an individual's credit file, but you are able to obtain reports which indicate whether or not a judgment debtor is operating credit or bank accounts, whether or not they're active, which should give you a bit of insight. An alternative is getting a good asset tracing agent on board as quickly as possible. Once you've collated the evidence of your of the assets, it's important to preserve and note all the steps that you've taken, and then really consider whether, particularly if the sum you're wanting to claim on behalf of your client or your company, if you're in-house counsel, whether the sum is large and the judgment debtor is likely to take steps to dissipate their assets and therefore render the whole process useless. If there is a significant risk of dissipation of assets, then you can potentially obtain a freezing injunction. They are very effective. Lawyers in this jurisdiction will know that they're called the nuclear option, and that's because they really ramp up the pressure on a judgment debtor, restrain them from dealing with their assets, and cause all manner of problems for the judgment debtor. But a court will want cogent evidence of the risk of dissipation. A debtor simply being uncooperative isn't enough. And of course, you would need to be full and frank in your disclosure in any such application to the court. The next thing that you will need to consider, once you're satisfied that there are assets in this jurisdiction, and hopefully you'll instruct a solicitor and a barrister, and I can think of no one better than Maria, of course, you'll want to turn your attention to drafting the claim form and particulars of claim. The claim form and particulars of claim, for those of us not in this jurisdiction, set out in fact and in law why there is this claim. Now, again, remember, this is a new case, a new claim, and it's going to require a new claim form. And the rules in this jurisdiction on how to serve that claim form are very, very strict, and very distinct rules apply. English procedural rules are a great deal stricter than some other jurisdictions that we're considering. And broadly speaking, the court is not going to be your friend. So the second you have this judgment come across your desk, whether you're general counsel or a solicitor, you need to really carefully consider who you need to serve, how you're going to serve them, where you're going to serve them, and by what time. An error in any of these steps may mean that you have to either start again, or it could be a lot worse if there are limitation problems. Defects in how you serve can be remedied retrospectively, but increasingly we are really seeing quite a hardline approach from the courts in their reluctance to, particularly where solicitors are involved, to paper over any of the cracks or the errors that are made in service. A top tip that we see time and time again when we're asked to get involved in these sorts of matters is where lawyers have served claim forms on solicitors just because they were on the record as acting, but prior to that solicitor agreeing to accept service. So I'm sure practitioners, particularly litigation practitioners in this country, know this, but just because you have a solicitor on the record as acting doesn't mean, it's not axiomatic that you can serve them properly. And now I'm going to talk a little bit about where and when you serve. So where to serve? Again, it's a vital thing that needs to be undertaken, and it's sometimes a really difficult first step. CPR 6, so litigation, as English litigators will know, is governed by the civil procedure rules. CPR 6 needs to be studied really, really carefully. In very broad terms, you will need to obtain the court's permission to serve a judgment debtor who is domiciled outside of England and Wales, unless some jurisdictional gateways exist, which will mean that you can obtain permission or automatic permission, at the time of issuing. This doesn't necessarily require a full-blown hearing, depending on the country that you are looking to serve out to. You will be on particularly strong ground in terms of what you need to do in serving outside of the jurisdiction if the original dispute arises out of a contract which prescribes how and where to serve. So another top tip: if the dispute arises out of a contract, always check the contract and see if there are some contractually agreed methods of service which are going to remove potentially some headaches in terms of exactly what you need to do procedurally to get the claim form out of this country. Of course, if the debtor's domiciled in England and you can prove it, working out service is just a great deal easier. And I'm talking about service, the claim form here, and CPR 6 is your friend. It's pretty clear when you're dealing with those that you want to serve in this jurisdiction. Even if the judgment debtor is not domiciled in England, you may have all seen when you land at Heathrow or Gatwick, people holding up signs with someone's name on. Until I started litigation, I assumed that was because they were posh people about to get chauffeured. In fact, at least half of those people holding up the signs are process servers looking to serve someone as soon as they land in this jurisdiction. And that's another quite good way of skipping all of these procedural hoops, serving someone personally within this jurisdiction when they land fresh off their flight from Buenos Aires and getting them seized by personal service of this matter. So if permission is required, you will need to make an application. That's going to be a without notice application normally, and it'll need to be supported by a witness statement. Maria's referred to translations of documents in the judgment debtor's tongue. That's really important, and not getting this wrong or choosing the wrong language or dialect really can be a fatal mistake. I heard a tale once of documents being translated into Spanish because of a solicitor's misunderstanding of the national language of Brazil. That's not only embarrassing, I think some of us might call that negligence, and it can fatally derail a claim. And don't forget, again, this is probably going to be without notice application, and in all without notice applications, full and frank disclosure of all facts, both supporting and undermining of your claim, need to be put before the court. Thinking about, so we've dealt with, in broad terms, serving out, who to serve and how to serve. The next thing that you should really turn your attention to is when to serve. And again, I've got to reiterate, there are some very strict time limits in this jurisdiction that emerge from the CPR. So this is part 7, Civil Procedure Rules. And an error in timing, so serving out of time, is something that, particularly if lawyers are involved, the court is going to be incredibly slow to remedy. So if you're serving the judgment debtor in this jurisdiction, then it's straightforward. You've got 4 months, and generally speaking, I would have thought 4 months. If you've got your ducks in a row, you know who to serve, you've got their address, and you've studied CPR 6, then 4 months should be enough time. The issue comes when you are trying to serve outside of the jurisdiction. You get an extra 2 months, so you get 6 months from the date of issue to serve, which sounds like quite a long period of time, 6 months, but really it isn't a long time at all. In practice, service of a claim form overseas regularly takes many, many months. For example, the Foreign Process Office at the Royal Courts of Justice estimates that the time for service of a claim form in the UAE from this jurisdiction is approximately 8 months. And in China and Russia, the time can be up to 12 months from the date of starting the process of issuing out. Therefore, even if you start the process of serving out as soon as you get your issued claim form, in some jurisdictions, you are going to almost certainly be out of time looking at CPR 7.5. So at the point of issuing, it's a really good idea to immediately make an application seeking an extension of time. And judges are aware of this. They're aware of the time the process takes. They're aware this isn't straightforward. And an application made way before the time limit is up is going to be received infinitely better than an application that's made when the time limit has expired or very close to the expiry. And it's the fact of the amount of time this is going to take for the claim form to go through the diplomatic channels to get to the judgment debtor in, say, China, that is another good point in seriously considering a freezing order, as there could be a really long time between the date of issue and the date you eventually get to serve. A top tip, if you're in the business of drafting contracts or drafting new contracts, service by email is possible, but will either require agreement or an application under CPR 6.4, as I've set out above. But in new contracts, so if you're involved in drafting contracts, why not put in a term that the courts will likely follow, that in fact service of any proceedings can be done by email and set the jurisdiction for England and Wales. You've then avoided a lot of headaches moving forward in new cases. If you do not take the right steps in respect of service, particularly with the time limits, and particularly in how you serve, and you don't validly serve, you will have a serious problem. If limitation issues arise, you've got a very, very, very serious problem. And again, I really am at pains to point out that the court is just not going to be your friend, particularly if, as I said, the errors relating to service occur outside the deadline to serve, and you haven't been proactive in seeking an extension in advance. Even if it's overseas, the courts are just not sympathetic towards it. So document everything you do in attendance notes, in emails, that evidences that from the very start you're turning your attention to how, when, and where to serve in the event you need to make such an application. A judge seeing that you've really turned your attention to this is going to really help any application if you need to make one. So I alluded earlier to limitation issues. So again, litigators in this country will be familiar with the Limitation Act, an act designed to send chills down the spines of litigation practitioners. But the key message here is that once you have a judgment from another jurisdiction, even though your client, whether your counsel, your in-house counsel, your corporate client, or whether you're a solicitor, your lay client, is that even though they've probably been through a lot of litigation to get this foreign judgment, they really shouldn't delay, because this can take time. Comparatively, the English limitation regime is stricter than many other jurisdictions. But as you can see from section 24, which is reproduced above, an action cannot be brought upon any judgment after the expiration of 6 years from the date on which the judgment became enforceable. So you've essentially got 6 years from the judgment to start your enforcement procedure in this jurisdiction. Now, we know that that is the case and remains the case because of the case of Tasarruf Mevudati Sigorta Foni against Demirel. This was a case involving a Turkish judgment where Sir Anthony Clark, Master of the Rolls, no less, expressly referred to the application of Section 24 applying to these sorts of judgments. So the message is: move quickly, don't delay, conduct your investigations, allow sufficient time, and even if further litigation is unwelcome, your client, whether it's a corporate client or a lay client, just needs to get on with it. So I'm now going to take us through what the conditions are for enforcing a judgment and how you can determine whether the judgment itself can be enforced and what tests will be applied by the court. I'll take you through these now. They're listed there, so that is that the judgment is final, binding, conclusive for a definite sum, and the foreign court had jurisdiction over the defendant judgment debtor. I'm sorry to labour the point, but I'm going to. You've got to remember, this is a fresh claim, so you will need to argue the above points to convince a court to give you the judgment that you seek. I'll take you through those now. So, as Maria, I think, alluded to earlier, the English courts will not allow the enforcement of a judgment that is not final. The obligation is upon you to show that the foreign judgment is final and all avenues of appeal have been exhausted. To evidence that, it's wise to consider evidence from a lawyer in the local jurisdiction stating under oath that the judgment is indeed final and explaining why no routes of appeal exist or have been exhausted. Without this evidence, or if there is a dispute about the evidence as to whether or not it is final, then summary judgment, which should be your aim throughout all of this, it is going to be, your ability to get that is going to be dented, and this could lead to a triable issue, which you don't want. You want summary judgment as soon as you possibly can. What's quite interesting is that the judgment that a judgment can be final, binding, and conclusive, even if the judgment actually didn't go before the court. And again, I think Maria alluded to this earlier. So administrative judgments, such as in Midtown acquisitions against ESA Global, that was a case that essentially involved a debt, and the judgment debtor confessed by way of affidavit in New York, and a court official stamps the affidavit, finds that this gets lodged as a judgment, and the court in this jurisdiction found that even an administrative judgment with a rubber stamp is capable of being enforced. So don't think that the lack of any court proceedings in the foreign jurisdiction is a barrier to the final, binding, and conclusive. Moving on to the requirement that the judgment is for a definite sum. Thanks, Maria. Maria's in charge of progressing slides forward, so she's multitasking, and we didn't want a situation where I was doing a Chris Whitty and having to shriek, next slide, please. So judgment is for a definite sum. This one's typically not a difficult hurdle to overcome. The majority of judgments, wherever they're obtained across the world, are for a defined sum of money, and I think it's likely that most judges in this country will be able to comprehend what that sum is. However, if the judgment is unclear, consider if this is capable of being remedied locally, i.e. by clarification from the local court, the foreign local court, I should say, or whether witness evidence again is required from a local lawyer to add some colour. So again, you're limiting the tribal issues and you're razor focused on how we get to summary judgment. Elements of judgments that can't be enforced are those which are not monetary. An injunction or an order for specific performance, if I can get my words out, cannot be enforced as a judgment in this country. It's got to be for a definite sum. So, for example, if you're acting for the Boston Traffic Fine Enforcement Agency, you can't use this process to obtain payment of traffic fines. It can't be for unpaid taxes, fines, or penalties. An injunction or order for specific performance, it's got to be for a definite monetary sum. So we also need to prove that the foreign court had jurisdiction over the judgment debtor. It's a fundamental condition that you can evidence that the foreign court had this jurisdiction. If the defendant disputes that the foreign court had jurisdiction, the English court will consider the issue by applying the rules of English private international law, not the laws of the country in which the foreign court is situated. This is where it starts to get a bit tricky, but I'll hope to take you through these fairly quickly now. So there are different positions in respect of an individual and a body corporate. So to prove that the foreign court had jurisdiction against an individual, you're going to want to look at the elements established in Rubin against Eurofinance. So these are the four gateways to evidence that the foreign court had jurisdiction. And essentially, the more you can get into your witness statement in support of enforcing the foreign judgment, the better. The first case is fairly elementary, and that is that the individual judgment debtor was resident in the foreign country at the time the foreign proceedings were commenced and was properly served. This will be sufficient in and of itself and alone for the court to have jurisdiction. And that was decided in a case called Emmanuel against Simon. However, where the defendant was present but not resident at the time the proceedings were commenced, again in the foreign jurisdiction, the English court may still, applying English rules, agree, a bit like the Heathrow scenario that I described, that they had been properly served and therefore the foreign court had jurisdiction. Second case is a lot more straightforward. If you're enforcing a judgment against a claimant or the claimant of a counterclaim, well, the very fact of them bringing a claim in their local jurisdiction evidences that the foreign court must have had jurisdiction. QED, you're on fairly safe ground in that case. The third case is where the judgment debtor voluntarily submitted to the foreign court. So even if there was a potential dispute that the judgment debtor could have run about jurisdiction, if they engaged in proceedings, then they will generally have been taken to have submitted to the jurisdiction. The fourth case is one that doesn't crop up that often, and that is if the parties have submitted to the jurisdiction of the foreign court by agreement. So, for example, prior to the commencement of the foreign proceedings, the defendant may have agreed to the jurisdiction of the foreign court to determine the subject matter of the proceedings by way of a jurisdiction agreement in the contract between two parties. But whether there is an agreement between the parties to submit to the foreign court's jurisdiction will be a question of English private international law. So again, you've got to remember that you are dealing with, or the courts will be dealing with, English private international law. So the laws of the local country that surround submission to jurisdiction are important. But to be clear, the English courts will be applying English private international law. Moving on to evidencing jurisdiction by or with a company or a corporate. This is slightly more straightforward than an individual, and the test of jurisdiction is essentially satisfied if the corporation was carrying on business at a definite and fixed place in the foreign country. And the basic principle is that a trading corporation will be regarded as present within the jurisdiction of the courts of the foreign country if it has established and maintained a fixed place of business and for more than a minimal amount of time has carried on its own business there, or if it has a representative, a branch office, that representative or branch office has for more than a minimal period of time been carrying on that corporation's business in that country. Practical considerations that remain in terms of how to proceed against a company or a body corporate, particularly when you're involving representatives or branch office, you really need to look at the functions that the representative performed and their overall relationship with the head corporation. Of particular importance will be whether the representative had the power to bind the corporation, and a lack of such power will be regarded by the English courts as a powerful factor against finding that the corporation's business had been conducted in that foreign country. Other evidence you might want to look at is whether the corporation's name, for example, was displayed in transactions, was on contractual documents, and was subject to control which the main body corporate applied. So that's a fairly whistle-stop tour through some fairly complex elements of what you need to prove. And the jurisdiction limb is one of the ones that can be the most tricky. It has essentially the most law in it. The final, binding and conclusive is normally a fairly simple tick requiring expert evidence. Judgment for a definite sum is normally a fairly big tick that you can overcome. But the jurisdiction point is definitely the one that requires some really, really careful thought. So I'm going to take a deep breath and have a sip of water, and I'm going to hand you back to Maria to consider the applicable defences that a judgment debtor may raise.
Yes, thank you, Matthew. That was very comprehensive. Don't worry, everyone. All the slides will be made available after today's seminar. So going on to deal with the applicable defences, in an ideal world, we hope that a defendant won't file a defence. And in fact, there's very limited circumstances in which a defendant can try and stop a judgment from being recognised. Over here, the courts are very clear that they will not be looking behind the judgment of the foreign courts. They will not be reassessing the judgment on the merits, on any questions of fact or law, even if a decision may be wrong. But often defendants do file defences, and it's really important that a practitioner needs to get on it and make a prompt application for strikeout and or summary judgment to get that defence struck out and summary judgment entered as soon as possible. In fact, there's a couple of people on the webinar today that I've got cases going on with at the moment where a defence has been filed and we've had to go through the defence, look at whether they have raised any valid arguments that can be relied upon, and make a quick application to get it struck out. So the main defences are as follows. So, has there been any breach of natural justice in the foreign court? For instance, has a party been prevented from making submissions? Did the party have due notice of the proceedings? Has there been any procedural defect which constituted a breach of the English court's view of justice? And a good case is Adam and Cape Industries PLC. This was a company which was based in the UK. They had a subsidiary in Illinois, and they were actually sued in the state of Texas. Effectively, the court found that to recognise the judgment here would be a breach of natural justice because, one, they were not present in the jurisdiction, and two, they had not submitted to the jurisdiction either. So the court found that there had been a breach of natural justice, and therefore the judgment could not be recognised here. Secondly, was the judgment obtained by fraud? Now, when we look at fraud, the fraud effectively has to go to the very heart of how the judgment was given. It can't apply to peripheral matters. It has to go to the real operative part of the case, and the fraud had to be operative in obtaining the foreign judgment and the order in issue. Essentially, without the fraud in the case, effectively the order would not have been made. But the fraud in question, it has to be really operative and go to the real heart of the matter. And I referred to a case there, the case of Gelly and Shepherd, and essentially the defendant tried to state that the judgment could not be recognised because some fraudulent misrepresentations may have been made throughout the trial. However, that argument was not accepted as it wasn't operative, and also other evidence was heard which was not fraudulent, so the judgment could be recognised. Public policy grounds. So obviously there are many jurisdictions in the world, and the court has to consider, would recognising that judgment here be contrary to any public policy principles? Would recognising the judgment offend any universal principles of morality? Would any human rights considerations arise which could possibly prevent recognition? The case I've referred to is a helpful case, actually, a 2020 case, GFH Capital Limited and Hay. And this was a DIFC court judgment which had been obtained by immediate judgment, which is effectively the equivalent of summary judgment here. And the claimants applied to recognise the judgment in England. The defendant was an English national, and the defendant raised all of these arguments, actually. He tried to raise an argument of fraud. He tried to refer to the public policy defence. He tried to state that effectively he was denied of legal representation and wasn't able to attend the trial in the DIFC courts itself. But the reality was that at various different points in the litigation, he did have counsel represent him, and he was even sent a slide link. Sorry, I got distracted by that slide popping up there. He was even sent a Skype link to be able to attend the trial remotely, and declined to do so. So that argument was not successful before the courts here, and there was no arguable public policy objection, no other defences that could be relied upon, which prevented the judgment from being recognised. So the number of defences are very limited.
Great, thanks, Maria. So it's back to me to now talk about summary judgment as a way of expediting the enforcement process, and that's what you're going to want to be really razor focused on from the outset. As Maria has alluded to, there aren't actually that many defences, and as long as you've got your 5 grounds, your 5 conditions for enforcement satisfied, then you really should be thinking about going for summary judgment as soon as humanly possible. So what is summary judgment? To practitioners in this jurisdiction, particularly litigation practitioners, we should all know what it is. It's an application made to the court under CPR 24, and essentially it invites the court to determine the dispute without trial. It's a much quicker alternative than going to trial, and it is the preferred route given the limited defences available to a judgment debtor, as Maria has explained. Again, it's important to remember that proceedings in this jurisdiction to enforce the foreign judgment represent a fresh claim. So this matter could proceed to a trial, but by aiming for summary judgment, you're shutting down the triable issues, and you're going to be convincing a judge that the debtor's defences cannot succeed. So what is the test? CPR 24.2, that the defence has no real prospect of success, and that's contained in CPR 24. If you're applying for summary judgment, it will be necessary to provide sufficient evidence to satisfy the court that the judgment was, as we have discussed, final, binding, conclusive for a definite sum, and that the foreign court had jurisdiction. If you can prove those points to the required standard, you will hopefully succeed in an application for summary judgment. And once you've sort of got over those hurdles, the evidential burden then shifts to the judgment debtor, who becomes the respondent, to in fact show that there is some real prospect of them successfully defending the enforcement of this judgment, or that there's some other good reason for a trial. Now, there's lots of good case law on what no real prospect of success means, but I picked out two examples that I think are just a bit easier to grapple with. What does no real prospect of success mean? Well, comparatively recent case, Burnden Holdings against Fielding, it doesn't require the judge to look at probability, but is looking at an absence of reality in terms of the prospect of the defendant succeeding. And as that reiterates, it's for the party bringing the summary judgment application to demonstrate first that the defense lacks reality. The prospects of success by the defendant, they don't have to be particularly high, but the claim must be realistic as opposed to fanciful. A realistic prospect is one that is more than merely arguable and carries some degree of conviction. But again, if you've evidenced the 5 grounds sufficiently, supported by local expert evidence, it really is going to be an uphill struggle based on the defences available to the judgment debtor, that this is not a good case for summary judgment. Now, there's a case called Easy Air Limited against Opal Telecom. That's the leading case on summary judgment. But another slightly more easier to digest case is on the next slide. And this is something we see quite often, and that is when defendant respondents to summary judgment applications put in their witness statements, they throw the kitchen sink at their witness statements, trying to convince a judge that in fact the underlying matter was so complicated and so difficult that summary judgment just isn't available because it's just too difficult for a judge to get his head around in a comparatively short summary judgment application. But that is the wrong approach if you are a defendant. As Lord Justice Neuberger said before he went to the Supreme Court, a judge is just not going to be distracted by extensiveness and complexity. A judge isn't going to be worried by this, and a defendant trying to use complexity as a mask is just not going to wash. A judge is going to quickly be able to see, cut through the complexity and quickly be able to see whether there is an arguable defense to a claim. So don't let complexity particularly concern you. So in terms of the process, comparatively straightforward if you've done all of your legal work on assessing your grounds and the defences. You make an application to the court. The application fee is comparatively modest. It's supported by a witness and a witness statement and expert evidence if required. The witness statement will usually come from your solicitor with conduct of the matter, explaining how the evidence supports the summary judgment test. Do not forget to translate documents if required, if the debtor's mother tongue isn't English. Again, it's a new claim, so the judgment debtor has now become a defendant respondent and will be entitled to file witness evidence in response. Inevitably, skeleton arguments will be exchanged by barristers on each side, and an oral hearing is inevitable. There's small scope for this to be dealt with on the papers, but it's never happened in my experience. I don't think Maria's either. An oral hearing is just inevitable. An important thing to remember is that both before and after you've made your application for summary judgment, this is a claim like any other. So don't forget CPR 1.1 and the overriding objective and the duty on litigants to try and settle their disputes without troubling the court. So even though you might be ricocheting towards summary judgment, and even before you've issued your standalone claim to enforce in this jurisdiction, it's really worth, from a cost perspective, to start considering whether you should be making early offers to settle this to avoid troubling the courts. So that's a whistle-stop tour through the process, and I think Maria is going to well, no, in fact, sorry, I've got one more slide, and that's where I talk about the outcome of summary judgment. Forgive me. So, if all goes well, then the summary judgment will result in a judgment that can be enforced in this jurisdiction. Hurrah! Not in all jurisdictions, the loser will pay the winner's reasonable and proportionate costs, reasonably and proportionately incurred. A recovery rate of your client's legal spend of about 80% is probably to be expected. If, regrettably, you don't succeed, then this matter is going to proceed to trial. Why is it going to proceed to trial? Well, because it's a new claim with some triable issues, and a judge is going to want to explore those. At the end of the summary judgment hearing, the judge presiding over it will order directions, and again, you will proceed to trial. As a result of losing the application, the loser will pay the winner's costs on a similar basis to above. In some cases, this is comparatively rare, a judge may make a conditional order, and that is the ability for a judge to make a conditional order is found within, not within CPR 24, but within CPR 3.13. And a conditional order would be one where one of the parties may have to pay a sum of money into court, and there will be consequences of a failure to comply with that order. Or a different order ordering the adducing of different or other evidence that might not be before the court, if the court thinks that there is some merit in the defendant respondent's position. So that's what summary judgment, the three potential outcomes look like. Of course, you're always going to be aiming for the first, and for the reasons that I hope we've set out, you have generally, if you've risk assessed well and you've evidenced your 5 grounds, you're on pretty good ground for succeeding the summary judgment application. So now I think is the time that I'm handing over to Maria for some more practical tips on summary judgment, particularly from a witness statement perspective.
Thank you, Matthew. Yes, so witness statements. It's very important that in the statement for an application for strikeout and summary judgment that we are boxing off all of the requirements that need to be addressed. So we need to, first of all, be discussing the judgment that we're asking the court to recognise. We need to refer back to the initial proceedings and the claim form and the judgment itself. We need to have a look at the defence and address any failings of the defendant to comply with the requirements of the CPR within their defence, because often a defendant may be a litigant in person, so they may have prepared the defence themselves, and there's many points that litigators can rely on in seeking to have that defence struck out and or summary judgment granted. Set out the basis upon which the judgment may be recognised by the court. And finally, we need to highlight the main defences and how none of the defences raised by the defendant actually apply in this instance. So the test for either strikeout in CPR 3.42, that the defence is an abusive process, or that it pleads lots of points that, simply make no applicable defence apply, will result in the case being struck out or summary judgment granted. So it's really important that the witness statement boxes off all of those elements. So once we've got the, bear with me 1 second, I'm getting distracted by these polls that are coming up. It's because I'm multitasking, Matthew.
Sorry.
Lots of things going on my screen. So once we got the judgment recognised, we know that the overall aim, that what we want, the end game, is to be able to actually enforce that judgment and take various enforcement action by way of third-party debt orders, charging orders, orders for the possession of sale of land, orders requiring judgment debtors to provide information about their assets, orders relating to various insolvency procedures. So that's the whole basis upon which we are going through this exercise. Matthew, is there anything else you want to add on enforcement?
I think particularly against company directors, the the steps we can take to enforce judgment against them are quite unpleasant, and can have quite serious consequences for their professional life. So, for example, as a solicitor, I'm not allowed to have a judgment debt unsatisfied against me. So if you're individual director of a company, or individual in his own right as a solicitor, that's a real point of pressure. But company directors and other individuals who have judgments against them can really cause a lot of problems in their professional lives. It can cause credit problems, stop them being company directors in extreme circumstances, and can mean that they really struggle to get car insurance, mortgages, mobile phones. So there are a lot of things you can do once you've got that judgment to really make the judgment debtor's life quite uncomfortable. One of the ones that we have on there is for an order requiring the judgment debtor to provide information about their assets. That takes place in a courtroom where a grumpy court clerk in front of a judge asks for an individual debtor to provide information about their finances. If they lie, they've done so under oath, and that's quite problematic. So there are lots of things we can do once we've got this judgment that's recognised to enforce, that can actually make someone's life quite unpleasant, and most importantly, lead to the realisation of assets and cash. And that's what we're all about when we're talking about enforcing foreign judgments.
Okay, wonderful. So we have taken actually quite a lot of time on the content, which only leaves us roughly about 5 minutes for questions. But both Matthew and I are more than happy to respond to any questions by email. If
Absolutely.
somebody has a case that they have going on at the moment that they're not quite sure about, please send us an email and we're happy to deal with that. Matthew, should we have a look at the chat box and some questions and answers now? Unfortunately, because I've been multitasking, I haven't been able to keep an eye on that as well.
Yeah, 100%. So we have a very good question, which is whether a hybrid judgment for specific performance and damages can be enforced if you just want to enforce the monetary judgment element. Would that be okay? I've got no problem going first on that, and I don't know who asked this question because it's an anonymous attendee, but I think I'd want to really quite carefully study the text of that judgment, because depending on the way the judgment was given and whether the damages were somehow really pegged to the specific performance, I'd want to see if they could be untangled enough so that the damages are very, very standalone, and that's not going to be something that causes a judge a bit of a headache. So that's on my part, that's a slightly lawyer answer. But if the damages element of the judgment is very clear and defined, then I would have reasonably high hopes that that could be enforced. Do you want me to read that question again for you, Maria, in case you want to give a different answer?
No, I've got that. And also I've had a case recently where there was an order, the judgment had various different elements to it, but as you say, the specific performance aspect of the order was distinct and separate from the judgment debt, a certain sum that we were seeking to have recognised here. So again, it's about making sure that those elements are separate.
I can see we've got one question from a lady called Margaret, and this concerns the enforcement of a US family judgment obtained in 2010 with terms providing for the sale of property jointly owned by the parties as beneficial owners. I'd be getting a bit concerned that a judgment obtained in 2010 was of quite some age and falling foul of the Limitation Act. There are a number of arguments that can potentially be made about limitation, but as I referred to at, can I find the slide very quickly? Slide 15. It's really quite established that an action can't be brought upon any judgment after the expiration of 6 years from the date on which the judgment became enforceable. So it sounds a little bit like Margaret's potential judgment is a bit risky.
Yeah, I'm hoping Margaret hasn't had that case for a long time, and it's just came to her, and it's 2010. That's a bit of a problem, Margaret. We're happy to speak to you about that if you need to speak to us about that. Okay. Any other questions? Is there anything else happening in the chat box, Matthew?
The very nice James Thomas has said it's insightful webinar with excellent food for thought, and he'll be getting in touch with Ms. Mulla because he's got a case of interest, which is fantastic news. But other than that, I think unless anyone's got anything they want to hurl in either the chat box or the Q&A now, I think we're done. But just to reiterate, even if something does occur to you as you're lying awake at night, please feel free to drop Maria or I an email, and we'd happily have a chat with you.
Yes, wonderful. Thank you, everyone. Have a good afternoon. And like we say, we're doing an identical session tomorrow. So if anyone you know has missed this session and wants to join tomorrow, please send them to the session tomorrow.
100%. Thanks very much, everybody, and thanks very much, Maria.
Thank you. Thank you, Matthew.
See you, everybody. Bye-bye.